I will briefly respond to the issues raised by Kihara, and then I invite the chairman to address it quickly. There is no misconception that, but I want to begin that nilimwacha aongee kimtoke. You have been told that section 94 subsection 1 is what council is defining as normative derivative. That's a misconception. In constitutional law, that provision does not qualify to be defined by that doctrine. The simple reading of the word normative means it relates to a norm, a rule, or a thing that should be. So if you were to argue therefore that section 94 subsection 1 is to be constituted or to be construed as a normative derivative vis-a-vis the provision of Article 33, the question therefore posed to the court therefore in determining the norm in section 93 would be, in normal circumstances, how would court regard such a statement by the charge sheet? What norm is arising or accruing from the particulars of that charge? And must that norm conform to the provision of section 7 of the 6th schedule? Again, simple reading of derivative means which can refer to something that is derived or taken from something else.
Do you want it made more punchy for a general?
It's about, let's go to say, section 94 subsection 1. If you were to juxtapose it to the normative derivative doctrine vis-a-vis the provision of Article 24, cannot then be said to have accrued or arisen from the provision of Article 33. And that is why counsel misses the point. Of course, deliberately so, because he does not want to appreciate the fact that section 7 of the 6th schedule was enacted so that it can assist the court where an amendment has not been initiated by the relevant authority. I concede it's only Parliament that can legislate. Yes, that I concede. But in the absence of a legislation, what is the import of section 7 of the 6th schedule? And what is the scope of the application of section 7 of the 6th schedule? If the scope is not such, the scope of application is not such as this one. The reason why Parliament, the reason why the people of Kenya enacted section 7 of the 6th schedule, they were alive to the fact that not all laws that may suffer amendments or repeals upon the enactment of the new constitution. And therefore they created an avenue for a magistrate or a judge to have the flexibility of dealing with a situation as and when it arises. Of course, my learned friend would want to argue, on the contrary, that it calls you, it limits you and makes you rigid to the interpretation. That is not the expectation. He has addressed you on the question of the repeal. If, even when a repeal has not approved of a section that is not in conformity with the Constitution, the obligation of the court faced with such a challenge is to make sure that that section does not defeat the purpose for which the Constitution was enacted. And then where do you get that purpose? You get that purpose under Article 10. For the benefit of my learned friend who seldom practices criminal constitutional law, Article 10 says, the national values and principles of governance in this article binds all state organs, state officers, public officers, and all persons whenever any of them applies to the Constitution. That is not what you're inviting me to. Enact, applies or interprets the law. That is what you're inviting me to. This law, Section 19. Section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation.
Council should just stick to what came out and the law so that we are not able
He addressed you on the applicability of Article 10, Your Honor, and I have simply dealing with the question of Article 10. I invite you to apply the tool of the Golden Rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is the Parliament of the United Kingdom. Granted that this country was a protectorate as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya.
Your Honor, seriously.
Yeah, that's what.
Okay, I'll abandon that, but I know the court has noted. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, you must apply the tool that enhances the enjoyment of a right other than to limit it. And that you're being invited by Article 19, 20, and 21. To argue that Section 8 of the Magistrate Court limits you, again, would be to miss the point. There is no possibility that the Constitution can give you under Article 10, which provides, again about these values, and I want to just mention the value of human rights. That when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights exclusively? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take it away from you? Then when interpreting that Section 8, again, you must interpret it in a manner that advances the enjoyment of that right, other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, clause 2, paragraph B. And this, I'll leave it at this and then invite Mr. Kihara. Because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their arguments. What we understand, let me finish, sir. Let us just have courtesy. What we understand as a response, just sit and finish it.
So just sit down.
Yeah.
You know that they don't have a place to sit.
No, you are. We are pleading that in response, so that we don't agitate, we just issues that have arisen.
Okay, I'll abandon that argument. I'll take that protection. So that, Your Honor, I'll then invite my and try to proceed.
So, Mr. Jayne, before you invite,
yes, sir.
Don't you think if you urge me, as you have done, in view of that section 7 of the 6th section,
yes,
do you think that will be cited for judicial overreach?
No.
It will be a classic case of judicial overreach.
There is no judicial overreach because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
Sorry, this second time I'm not taking it. I am a master's holder in constitutional law. It's not. I am an advanced master's holder in constitutional law. It's not. So you should not throw those shades. I am extremely intelligent and brilliant and learned. You should not throw the shades.
It's one thing to hold a master's and
sorry, yeah, I'm not on trial, Your Honor. I'm asking you to just respect me because I am not. No. Yes, this is the second time counsel is attacking me and I seldom, but I am asking him to respect me because he's my friend.
Okay.
That's not the matter.
Yes, Your Honor.
Mr. Which has demonstrated his stellar credentials.
Yes.
Let's not challenge it.
And we are not surprised by those credentials, but surprised by the inability to apply the same.
I am not the kind of person to be intimidated by people like this and that. So this court should just direct him that he respects the court if he doesn't want to respect me. And if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from Islam, that I can't allow someone to just make shades. So please, just respect me.
Let's not extend that. I was actually about to praise the council for their appropriateness and their propriety, but now I think we almost extended.
Yeah.
Let's just maintain our code and decorum.
Well,
You already wound up. I was just expressing that perspective.
Yes, Your Honor. There is no judicial overreach because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who seeks to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial overreach, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most of that.
Thank you, Council. You're the last one, Mr. President.
The chairman has 2 sentences, just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Witty has a habit of always rising when I rise. If I stand, I can submit when he's standing. I don't have a problem. But let me make the submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention. If you allow me to read a paragraph, so that as he responds, they also tackle.
No, we are beyond that.
I am allowed to make an application to reopen.
He has already closed his case.
Yes.
I'll address that. Let's just finish with that.
Okay, that's fine.
Let's finish because they are responding to what you raised.
He cannot be allowed to be sitting.
I think the court has directed. The court has directed.
Yes.
Yeah, Jonas, very briefly, very briefly. There is a suggestion that we are inviting you to a mini trial prior to appeal. In many words, that's how we call it. We are not asking you to evaluate any evidence. We are only asking you to look at the content of the charge sheet in terms of the wording, and look at the relevant section of the law that is said to be based, and make a judicial determination in accordance with section 18, subsection 5. Also, section 194 of this case. That is all that we are asking for. When prosecution brings a case before you, a charge sheet that is before you and a suspect before you, it is in exercise of the ODPP's power under Article 57. We may talk about this. And as I had said earlier, this power must not be abused. Indeed, and Mr. Whitty knows this very well, that what sub-article 11 says is that that power of the DPP, in exercising the powers conferred under this article, the DPP shall have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. A charge sheet is brought before you that is clearly an abuse of the process. Your Honor, that is a charge sheet that you should reject, and the court gives you, the law gives you that power. Lastly, last today, Mr. Kibe Mungai told us in another setup, another court setup, that there's a reason why that the new constitution, the bar on this side, the defense, the prosecution, and the bench was made to be advocates. We no longer have police officers on that side, advocates, and then there used to be district magistrates on that side. Those days. Now we have advocates. So that when materials are brought before the courts, the level at which we interrogate them is not the basic level. We should present before the court and head before the court, and the court applies its mind, its legal mind, to assess a situation so that we prevent and avoid abuse of process. How do I say this? There was a suggestion by the Fred that when a charge sheet is brought before you, your role is to tell the accused person plead guilty or not guilty, and then evidence will come to prove or fail to prove. That is not what the Constitution envisaged. It envisaged a situation whereby all the parties would have some basic meeting of mind as advocates that indeed this charge sheet, we may fail in evidence, and this one is also in the position to charge guidelines. We may not attain 100%, but it is unreasonable. The charge sheet is in the direction of something that we can prove. So you're being told, yes, there's nothing threatening, there's nothing insulting, there's nothing offensive, but nonetheless, let her take plea. We will move along and see what we will do along the way.
I hope we didn't say that. I hope the record will help us.
Let's move. We'll learn where we find ourselves. We will decline that invitation and find that this is not a proper charge that the person before you should take. Thank
you. Well, I will be brief. And I will start by quoting Justice Odunga in Republic versus Director of Public Prosecutions and another, Spate Chamanlal Kamani, whereby Justice Odunga said this: the seat of justice is a hallowed place and ought to be preserved for those matters in which the protagonists have a conviction and stand a chance of seeing the light of day. And he adds and says that a trial is neither a showbiz nor a catwalk. Why am I saying this, Your Honor? Your Honor, the DPP under Article 157 has the prerogative to charge. Then again, it is not for sport. It must be exercised reasonably, lawfully, and within the constitutional bounds. The DPP, the office of the DPP, is assumed to be sane and rational. We operate on the gracious presumption that the office of the DPP is sane. But the prerogative to charge, Your Honor, isn't a license to experiment. What, Your Honor, we are telling you is that you don't need to taste the meal to know that something is off. Even the smell of it can tell you that there is something that is off. Finally, Your Honor, two issues. We are not asking the court to test the evidence. What we are inviting the court to do is to test the lawfulness and the sufficiency of the charges. Simple. A criminal trial is only justified where there is a properly framed charge that discloses an offensive law. So we are not saying that we should call witnesses right now. All we are saying is that the DPP has that burden of telling us that these charges are lawful and within the bounds of the Constitution. Secondly, Your Honor, a trial is not a fishing expedition. The charge must disclose a known offense with clear particulars and connect the accused's conduct to that offense from the get-go. If it fails these basic tests, then the charge collapses on its own weight. An accused person must be informed of the charges with sufficient detail. So, what we are saying is that the accused person ought to have known how her words amounted to offensive conduct under Section 94, which is not the case. the DPP can't say that when the court gave the right to stop. In short and in conclusion, we are not challenging the evidence. What we are challenging is the charge's existence as a valid document. If they insist on going to trial without a valid charge, then that's like building a house without foundation. Circumstances submit that charge is effective, and the accused person should be admitted to a personal cognizance. Yes. And they have considered to that. To have been released.
I just wanted to mention an authority.
Yes.
Yes.
So just share with us so that we can also assist the court.
Could I give the citation?
Yes,
Yes. Your Honor, the decision I'm talking about is the Supreme Court decision, a bench comprising of Baraga, CJ, Ibrahim, Ojuang, Anjala, and Joki, and the case is Hussein with a double S, Hussein Halid with a KH, and 16 others versus the Attorney General and 2 others. The citation is petition number 21 of 2017. And without making the arguments, it is in respect of this court's powers to enforce fundamental rights. So I'll refer the court to paragraph 118 and paragraph 120. Your Honor, if you allow me to just read. Paragraph 118, while that was the law then, the Magistrates Court Act number 26 of 2015 has since been enacted to give effect to Articles 23(2) and 169(1)(a) and 2 of the Constitution to confer jurisdiction, functions, and powers on the Magistrates Courts, to provide for the procedure of the Magistrates Courts and for connected purposes. Section 8 of the said Act vests jurisdiction in the Magistrates Court to hear and determine applications for enforcement of constitutional rights, but limited only to claims on freedom from torture and cruel, inhuman, or degrading treatment or punishment, and freedom from slavery or servitude, as guaranteed in Article 25A and B of the Constitution. The jurisdiction of the Magistrates Court does not also extend to determination of claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial, or a right or fundamental freedom in the Bill of Rights. 120. We therefore find and hold that there is now legislation that provides on how magistrates courts may determine allegations of infringement of fundamental rights. Though limited, the same is constitutional as an aggrieved person, while he might not on all allegations approach the magistrates court, still has recourse to the High Court, which is the court constitutionally empowered to address allegations or violations of the Bill of Rights. I thank you.
So I must say that that authority you said is open cited. Yeah, it's open in our corridors. Yeah. So thank you for that authority.
Yeah, but just to distinguish it, on one point, and I agree we are bound by the decision of the Supreme Court, but I will you not in a very few minutes to come enforce Article 49?
That one actually, I was about to say that. You thought, you had the thought in my mind.
We must, I will be seated where you are seated very soon.
I wish you that. All right. So I want to appreciate the council for such erudite submission and the decorum, the propriety. I want to thank you most sincerely. You've made extensive arguments and you cited authorities. We've not had a chance to look at those authorities in the case laws. And also you've cited so many provisions of the Constitution together with the statutory provisions you cited. So I'll request that I'll defer the ruling. I'll defer the ruling on that application to a later date. But we can now, as Mr. Jeru had indicated, now go to the issue of the accused person being either released, which is not opposed, I'm told. In the meantime, as we wait for the court to make a determination on the application, I believe that's agreeable.
Yes, that's agreeable. The court can determine whatever terms and conditions.
So to that end, I think I'm alive with the provisions of Article 49(2) of the Constitution. So to give effect to that, I'll release the accused person to a personal bond of 50,000. So the accused person will be released to a personal bond of 50,000 pending the determination of the application that we just had. Next week, I'm swamped with so many matters. Usually, I put my willing in 2 days, but unfortunately next week I'm not, so I'll do the other week, the week after next week. So that on the 29th, so I'm supposing if 29th is convenient, we can come back on 29th at 9 a.m. if it's convenient.
Could we do it on first now that the accused will be out on board?
Yes, first is it's amenable to all the parties. So let's first of all I do on the day.
You know, we have a
in absence of my new counsel, I should assume I've taken the role. The case, and I request for more convenient details. I thought I think I have a very complex issue. Yes, I will propose 6 hours. Proposal of the site, the 11th, there is a date that appears to be more convenient to the council.
We could go back to the 29th if
Or the
continue
29th,
with that.
the earlier the better.
Yeah. My colleagues will represent.
So if 29th is okay, usually the sooner the better. 29th.
We also agree that we give us study discussion and then we are preparing another hour other than 9.
Okay.
Let's say 11.
11. So we have it ruling on the 29th day of July. And then my last request, council of science sabotage. If you be kind enough to say so that I don't get, I get a different authority like the one in Thailand. To know that it's been changing. So
They should also ensure they serve us so that we can
so just submit it to us maybe by Monday.
No, we don't have a problem of exchanging and filing with you. What I'm reminding them is that whatever they give to you, they
should also share with you.
they should give us, if there is something that we could take comparing, we could put in a comment. Yes.
So I think just explain your submissions.
I think because of my years of practice,
Yes.
I'm not getting this where council says I have to give the undertaking before the court. When I'm already telling you we'll exchange.
You're like, it's on a light note. I just say that that's what you don't say you give us. And it's been colleagues are very combative. Yeah, so
Thank you again. And I wish you all a blessed
What's your